Waalaikumsalam warahmatullahi
Warahmatullahi wabarakatuh.
Good morning, everybody, and welcome to the second International Conference on State Law, Religious Law, and Customary Law, hosted by the Faculty of Law, Universitas Tanjungpura. Already join us here. Welcome to our distinguished Rector of Universitas Tanjungpura, Profesor Dr. Garuda Wiko, SH, MSI. Welcome to our distinguished Dean of Faculty of Law, Universitas Tanjungpura, Dr. Sri Ismawati, SH, MH. Welcome the Chairman of Pengadilan Tinggi Agama Pontianak. Welcome the representative of Dinas Tenaga Kerja dan Transmigrasi Provinsi Kalimantan Barat. Welcome the representative of Walhi Provinsi Kalimantan Barat. Welcome the representative of Pengadilan Militer Kota Pontianak. Welcome the representative of DP3A Provinsi Kalimantan Barat. Welcome the representative of BPPD Provinsi Kalimantan Barat. Welcome the representative of Pengadilan Tata Usaha Negara Kota Pontianak. Welcome the representative of Badan Pengelolaan Perbatasan Daerah. Welcome the representative of Kepolisian Daerah Provinsi Kalimantan Barat. Welcome the lecturers of Faculty of Law, Universitas Tanjungpura, all invited guests, and all participants who have joined online. My deepest gratitude also goes to organizing committee whose dedication and hard work have made this international conference possible. This year's theme, Exploring Legal Pluralism in Bonderland, Customary Law, Religious Law, and State Authority, is profoundly relevant to the current development of law, particularly in Indonesia and other multicultural societies. In borderland regions, where identities and jurisdictions overlap, the recognition of legal pluralism becomes essential to promote social harmony, protect indigenous rights, and ensure the legitimacy of law in daily life. May this conference serve as a platform for meaningful dialogue, academic collaboration, and policy innovation that strengthen the spirit of justice rooted in our diverse legal traditions. Ladies and gentlemen, to begin our event, please rise for the singing of our national anthem, Indonesia Raya, and followed by hymn of Universitas Tanjungpura.
Hadirin yang kami hormati, marilah kita berdiri untuk menyanyikan lagu kebangsaan Indonesia Raya yang akan diikuti lagu himne Universitas Tanjungpura.
Ladies and gentlemen, to begin our event, let us start with an opening prayer. May I invite everyone to bow their heads and join the prayer.
Untuk memulai rangkaian acara pada pagi hari ini, marilah kita awali dengan doa pembuka. Doa akan dipimpin oleh Saudara Etra Arbas SHMH. Waktu dan tempat dipersilakan.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. In this section, I will lead for Islam believer, and for non-other Muslim believer, please adjust to according your respective belief. Bismillahirrahmanirrahim. Alhamdulillahirabbil alamin. Wassalatu wassalamu ala asrafil anbiya'i wa mursalin wa ala alihi wa sahbihi ajmain. O Allah, O most compassionate, on this day in this conference hall of Tanjungpura University, we are about to hold second international conference on state law, religious law, and customary law. We seek your pleasure and permission. Bless every step and action we take, and make all of them this of worship and source of beneficial knowledge of us. O Allah, O the One, O the Universe, you are the one who is the most one and who unite all. Strengthen the unity among us, and don't let division arise between us. We wish to be strong in our unity so that we may bring greater benefit to religion, to our nation, and to this country. O Allah, O most forgiving, you are the most forgiving of our sins. Forgive our sins, the sins of our parents, our leader, your servants, who have struggled in your case, and our predecessor. Encompass all of us in your mercy and forgiveness. O Allah, O the answer of prayers, you are the one who responds to every supplication. Please accept our prayer and our humble request. Rabbana atina fid dunya hasanah wa fil akhirati hasanah wa qina azabannar. Subhana rabbika rabbil izzati amma yasifun. Wassalamu ala mursalin. Walhamdulillahi rabbil alamin.
Thank you, Mr. Etla Arbas. We'd like to sorry before that due to his busy schedule, Mr. Governor can attend this conference and give the keynote speech. So we will continue to the next event. Ladies and gentlemen, let us hear the opening remarks from the Dean of Faculty of Law Universitas Tanjungpura.
Hadirin yang berbahagia, berikutnya kami mengundang Ibu Dekan Fakultas Hukum Universitas Tanjungpura untuk menyampaikan sambutannya. Pada Dr. Sri Ismawati SHMH, waktu dan tempat dipersilakan.
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. Good morning, greetings, prosperity, and heart for all of us. The Honorable Rector Universitas Tanjungpura, the Honorable Speakers, Panitia, please connect to Zoom meeting. Speaker. The Honorable Speaker, Prof. Gary C. Lilienta from Nazar University, Dr. PG Ismail bin PG Musa from Malaya University, Dr. Bhupinder Singh from Sarda School, India, and Dr. Eka Ardianti Putri from Universitas Tanjungpura. For speaker, thank you for your time and for joining this conference. The Honorable, the law enforcement official from regional, police, prosecutors, and courts, all the dean of all universities in West Kalimantan, the head of office, head of institution and agencies of government in West Kalimantan, the head of traditional council and the head of customary council in Pontianak city environment, the head of NGO in West Kalimantan environment, the Honorable First Dean, Section Head of Study Program from Faculty of Law, Universitas Tanjungpura. The Honorable Lecturers in the University Tanjungpura, especially representative of the Manpower and Transmigration Service in West Kalimantan, representative from Walhi, representative of State of Administrative Courts, the representative of the Regional Border Management Agency, the representative of the Regional Police Kalbar, representative of the Military Courts, and the Honorable Prof. Oramahi from LPMPP, Universitas Tanjungpura. Last but not least, the honorable guests who cannot be mentioned by one, but it will not be listening or respect to all of you. First of all, let us invite you here to say Alhamdulillah and gratitude for the blessings and mercy from Allah Subhanahu wa Ta'ala that we are still given the opportunity to be here in the second international conference, even with the topic exploring legal pluralism and the borderlands, customary law, religious law, and state authority. Secondly, on behalf of the faculty, I extend my highest appreciation to our four distinguished keynotes and plenary speakers. Are from Prof. Gary, Prof. Ismail, Prof. Bhupinder Singh, and Dr. Eka Ardianti Putri for their valuable contribution to this year's conference. Your expertise and perspective enrich our understanding of law. It is plural and dynamic contents. My deepest gratitude also goes to the organizing committee whose dedication and hard work have made this international gathering possible. Ladies and gentlemen, this year's topic is exploring legal pluralism in borderlands, customary law, religious law, and state authority is profoundly relevant to the current development of law, particularly in Indonesia and other multicultural society. Legal pluralism recognizes that law does not exist solely within the state's formal boundaries, but also thrives within communities, religions, and tradition. It is through the interaction and sometimes tension among the system that justice becomes more contextual, inclusive, and responsive to social realities. May the conference serve as a platform for meaningful dialogue, academic collaboration, and policy innovation that strengthen the spirit of justice rooted in our diverse legal tradition. Once again, I thank you for your presence and participation. May Allah always bless our efforts. please apologize for any shortcomings. Taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Thank you for the speech, Mrs. Bin. And now, this is the time it is our distinct honor to invite the Director of Universitas Tanjungpura to deliver the opening remarks and opening this conference.
Dengan hormat, kami mengundang Bapak Rektor Universitas Tanjungpura untuk menyampaikan kata sambutan sekaligus membuka acara. Kepada Bapak Profesor Dr. Garuda Wiko, SH MSI, waktu dan tempat dipersilakan.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semua. Distinguished guests, esteemed speakers, and honored participants. On behalf of Universitas Tanjungpura, it is an honor and pleasure to welcome all of you to the second International Conference on State Law, Religious Law, and Customary Law 2025. We are deeply grateful to this opportunity that let us reflect upon the theme of exploring legal pluralism in borders, custom, religion, and state power. Allow me to extend my heartfelt appreciation to our distinguished guests and institution representative joining today. Terima kasih atas kehadiran perwakilan dari Polda Kalbar, dari Pengadilan Militer, kemudian Pengadilan Tata Usaha Negara, dari Walhi, kemudian dari Badan Pengelola Perbatasan, betul ya? Oh, ya. Kemudian juga dari LPMPP, Prof. Oramahi. Thank you for joining this event, and especially for the Dean of Faculty of Law, Universitas Tanjungpura, Bu Sri Ismawati. And last but not least, there is an esteemed guest from Guangxi Bingchu University. Is there? Oh yeah. Welcome to this event. I hope your presence truly enrich this academic gathering by reinforcing the importance of bridging governance, policy, and community engagement. I also extend my highest appreciation to our distinguished keynote and plenary speakers, Professor Gary C. Lilienthal, Dr. P.G. Ismail bin P.G. Musa, Dr. Bhupinder Singh, and Eka Ardianti Putri for their valuable contribution to this year's conference. Your expertise and perspectives will enrich our understanding of law in its dynamic context. Ladies and gentlemen, this year's conference invites us to rethink the nature of law, particularly in borderland regions, where state authority intersect with plural society. The interaction of plural legal system reveal opportunities for inclusive governance, as law is most effective when it resonates with local identity. May this conference inspire meaningful discussion and innovative perspectives on the evolving landscape of legal pluralism. With that, I hereby declare the conference officially open. Thank you very much for your attention. Wassalamualaikum warahmatullahi wabarakatuh. Selamat pagi, salam sejahtera untuk kita semua.
Thank you, Mr. Rector. Before we continue to the next event, we would like to take a group photo first.
Akan dilaksanakan sesi foto bersama dengan para tamu, narasumber, dan seluruh peserta. Panitia membantu mengatur posisi foto.
Hadirin dimohon untuk mengambil posisi foto dari tempat masing-masing. Kepada Bapak Ibu dosen dari Fakultas Hukum diharapkan bisa maju ke depan. Bapak Al-Hadiansyah, Bapak Barulian, Ibu Evi Purwanti, Ibu Evi
Silakan maju ke
Purwanti,
depan, agak ke depan.
Ibu Endah Rantau, Ibu Lolita, Ibu Kepala Bagian, Bu Evi Purwanti, mungkin
Silakan
bisa.
ya, diisi ke depan. Agak
Ibu Ria, Ladies and gentlemen, we shall now proceed to our plenary session featuring our distinguished speakers.
Selanjutnya, kita akan memasuki sesi pleno dengan para narasumber terhormat, Prof. Gary Lilienthal, PhD dari Nalsar University of Law, Dr. PG Ismail bin PG Musa dari Faculty of Law, University Malaya, Dr. Bhupinder Singh dari Sarda School of Law, Dr. Eka Ardiani Putri Mars MH dari Universitas Tanjungpura. Sesi pleno ini akan dibodoraturi oleh Ibu Aniza Azal Ulfa, SAMH. Kepada para narasumber dan moderator, waktu dan tempat dipersilakan.
Assalamualaikum warahmatullahi wabarakatuh. Good morning, ladies and gentlemen. It is very nice for me to finally meet you on our special event today with your enthusiasm. And on behalf of the organizing committee, we are very grateful and thank you for your participation in this crucial intellectual endeavor. Before we start our agenda, which is the plenary session, let me introduce myself first. My name is Anissa Zulfa, and I can say it is a very tremendous honor for me to be your moderator today on this session of the International Conference on the State Law, Religious Law, and Customary Law. theme today is Exploring Legal Pluralism in Borderlands on Customary Law, Religious Law, and State Authority. Okay. As we know, borderlands are sites of profound legal complexity. And nowadays, the formal mandates of the state law intersects with the resilient norms of religious and customary systems. These sessions specifically aims to unpack these vital intersections and examine how these legal layers define justice and governance on the ground. And to guide us through this intricate landscape, we are privileged to have an exceptional panel of experts. First, we have Professor Professor Dr. Gary I. Lilienthal from Nalsar University of Law. Professor Gary I. Lilienthal holds Sydney University Law degree, Sydney College of Law graduate diploma in legal practice, a Melbourne High Distinctions Master degree in Freudian and Lacanian psychoanalysis, and a Perth, Australia doctorate in the history and development of the intellectual property of thought of passing off. He is now a professor of law by the Vice Chancellor's personal appointment at Nalsar University of Law. Professor Gary, welcome. The next one, we have Dr. PG Ismail bin PG Musa from Faculty of Law, University Malaya. Dr. PG Ismail bin PG Musa has pursued studies at the undergraduate, master's, and doctoral level at the University of Malaya, specializing in law and Sharia. His areas of expertise are the administration of Islamic and customary law in Malaysia, family law, and evidence. To Dr. PG Ismail bin PG Musa, welcome. And the next one is Dr. Bhupinder Singh from Sharda School of Law. Dr. Bhupinder Singh is a professor at Sharda School of Law and as Faculty of Political Science, North Bangkok University. To Dr. Bhupinder Singh, welcome. And for the last but not the least, Dr. Eka Ardiani Putri Mars MH from Universitas Tanjungpura. Dr. Eka Ardiani Putri Mars MH currently serves as lecturer at the Faculty of Medicine, Universitas Tanjungpura, and alongside her academic role, she is also the Vice Director of Medical Services at Universitas Tanjungpura Hospital. Ladies and gentlemen, please give applause to our spectacular speakers today. Okay, so here's a brief outline of how we will proceed the plenary sessions. So the plenary sessions will be divided into two sessions. The first sessions will be filled by Prof. Gary I. Lilienthal and Dr. PG Ismail bin PG Musa. And the second session will be filled by Dr. Bhupinder Singh and Dr. Eka Ardiani Putri Mars MH. And each of our speakers will have 15 minutes to present their key findings and arguments. 20 minutes, not 15 minutes. And we will dedicate approximately 20 minutes to dynamic Q&A sessions. So one speakers will have 20 minutes to present their presentations and have 20 minutes for the Q&A sessions. And I kindly ask our speakers to observe the time and limit, and I will give a gentle signal when you have 3 minutes remaining. And for the Q&A sessions, we ask that you please state your name and affiliations before posing your questions. Please ensure your questions are brief and directed to a specific speaker. And without further delay, let us begin our intellectual journey. And our first speaker is Professor Gary I. Lilienthal, who will present on the law of the cuneiform clay tablets. Professor Gary, the time is yours.
Good afternoon, everyone. Can you please put the PowerPoint up? Can the operator please put the PowerPoint up? Do we have the PowerPoints?
Steve, the PowerPoint, please.
No, we don't.
Don't have?
Yes,
Okay.
we have, sir.
Let me see if I can share the screen.
Maybe we can wait a second, Professor, because we're still preparing the presentation.
Can you see the PowerPoint now?
Not yet. Still loading.
No, it's still
It's loading?
No, it's still loading.
Yep.
Let me know when you can see it so I can start.
Okay, now we can see the PowerPoint now.
Try it again. No, I've sent you the PowerPoint. You should have it. Okay, no problem. You see it now?
Clear.
Yes.
Very good. Very good. So let's start. I'm going to speak to you today about this very stimulating topic that the university has chosen, combining customary law, state law, and religion. You know they're all related. Religion is the more archaeologically ancient version of customary law. It's arguable that there are two forms of law inherent in religion. The first is the more recent religious issues, and we call that law. And the more ancient issues religion, more than the archaeological period of 4,500 years old, we call that the agadic form of narrative law, and it transmits down the generations in narrative form. Okay, so today we're going to look at the ancient marriage and divorce law in ancient Babylon. And the theme of cross-border or at the border is heavily evident in this theme because you're going to see today something happening in law that we don't often see in today's law. And this is the field of what is called onomastics. Onomastics is the study of proper nouns, and really the only thing that's left over in the law today for onomastics is in divorce law, and especially in Southwestern Asian law, where they check the names of the divorcees very carefully to make sure that they are receiving the right form of divorce treatment. And we know that in ancient divorce law, that the document of divorce, the deed of divorce, is of the same property and structure as a deed of manumission, releasing the employee. Okay, so in ancient Babylon, can we go back please to slide number 2? Slide number 2. One more, slide number 2. Have you got it? There we go. We're going to look at how the law arose from the cuneiform clay tablets. Cuneiform is simply the form of writing that they had in Mesopotamia. And I'm very happy to note that my co-author, Dr. Salim Ibrahim Ali, hopefully is present today from the University of Mosul in Iraq. Dr. Salim did the base research. He found the clay tablet research from which we construct this research. This research was published earlier this year as a 57-page paper in New York, Scopus indexed, in a journal called Advances in Sociology Research. Okay, next slide, please. Slide number 3. You'll see the slide number down in the bottom right-hand corner. So our research question for this research is, how did the governance of the ancient Babylonian state affect the social contexts of naming systems and the legal forms of marriage? Naming systems and marriage, they're linked together. That's the amazing thing. Our preliminary statement to answer the research question, which researchers will know we call a thesis statement, is as follows. Ancient Babylonian marriage was a primary mechanism of social stratification, directly regulated by the state. You know that in ancient times, if you wanted to marry, the man and the woman simply married and announced it to the public. But then later on, in Babylonian times, it became an official government-regulated activity. The form and content of marriage agreements were not merely private matters, but reflected and enforced class boundaries. Now we'll see how. Next slide, please. Slide number 4. Good. So the naming systems, or the onomastics, were indicative of the social contexts in which marriages were regulated, from the elites to the lowest classes of ancient Babylonian society. And let me tell you that this entire regulatory system was centered in the ziggurat, which today we call a temple. And in the ziggurat, the largest ziggurat in Babylon was the Egibi ziggurat, run by the Egibi family. So you had a temple run by a family. And can you guess what the specialty of the Egibi family was? They were bankers. They ran the temple as a bank, and they were apparently the world's first bank. So you see very unusual things that you might not see in a mosque today. I don't know if any mosques have banks or not. I know here in Australia, the churches certainly don't have banks, even although they have a lot of money. But in the ancient times, the ziggurats had a bank, and that gave them their power. And within those temples, next slide please, next slide, within those temples, there was social stratification. We'll pass over this one, I've discussed it. Next slide, please. One more, up to number 7. And the social stratification was we had the priests, we had the oblates, O-B-L-A-T-E, the oblates, and arguably today, in our times, lawyers are oblates to the temple of law. They were people who were attached to the temple. They had to earn their own money. If no clients came to them, or if they couldn't earn money, they were cast out and had to go and look for more money, just the same as lawyers. And then there were slaves in the temple and the general commons of the society. So we'll see in the legal archaeology of what we're studying today the origins of contractual clauses, property rights, and family law. 3 huge areas of law. Next slide, please. So this is a classic case study of how law is used as a tool for social control and maintaining class structures. Now, the great anthropologist Levi-Strauss said that in the beginning of the times when writing was invented, its main purpose was the enslavement of humans. So we have to ask, why were the clay tablets inscribed with cuneiform writing? Why did they have registries of marriages and divorces? And why did they have to be stored? And the answer is because the various kings in ancient Babylon had government archives. Next slide, please. Government archives. Every country today has a government archive. And you know, when we have our email system and we discard an email, we say, oh, well, I'm archiving it. It's not the true meaning of archives. I want to teach you today what archive really means. An archive is a document. So the cuneiform tablets were in fact archival documents. And these documents were evidence of an administrative decision taken by a government authority. And all the countries today have their national archives, and they may have hundreds of professional historians in there checking what's called the provenance of the archive. Provenance means where the document came from, how it was formed, how it was structured. Before I mentioned to you the structure of a deed of manumission being similar to the structure of a divorce document. You see an archive structured like a divorce document, we can assume it's a divorce. So, the early forms of archives are the customs of society. The administrative decisions were made by customary reasoning. And as Cicero from the ancient Roman Empire himself said, that in the absence of a statute, a custom has the power of a statute. So we had the early beginnings of statutory law in registries called archives. Okay. Next slide, please. Slide 11. There we go. So we see here an example of comparative law. We're contrasting ancient legal narratives with modern legal principles regarding gender, status, and equality. These are arguments and discussions we're having today. What I want to communicate to you today, that everything we do today has come from our forefathers and our foremothers. It's come from thousands of years ago, and it hasn't really changed that much. It's been rearranged a little to suit modern conditions, but it's very ancient, which is why we should study the ancient law. And the study of religion gives us a very accessible method of studying ancient law. Next slide, please. Now, the kind of research that's been done here is called doctrinal. Nobody was interviewed. It's not qualitative research. In qualitative research, we interview people and we do a narrative analysis. But what we've done here is a doctrinal research project based upon the most authoritative scholarship and the available documents. The methodology is a legal, narrative, critical analysis. Now, for those who don't know, there are three kinds of narrative. There's a historical narrative, there's a mythical narrative, and there's a legal narrative. Legal doesn't mean law. It simply means that the narrative, a legal narrative, means that the narrative is structured into a number of historical narratives, each one dealing with a separate element. And from this we get the word law. Law is simply something that the state does that deals with a number of different elements, which you'll understand as the mischief that the legislature has identified and wants to resolve with the law. So we analysed a cluster of narratives from clay tablets. The prime source for this research were about 50 intelligible Neo-Babylonian marriage contracts from the 7th to the 3rd centuries BCE. This roughly coincides with what we call the Axial Age, which was an age of great illumination of scholarship. So the archives are skewed towards elite families. The lives of the lower classes are less documented. So, it means that an elite marriage was documented. There was a marriage contract that was in writing, and there was a dowry document that was in writing. These kinds of documents still exist to this very day in similar form. But for the lower classes, many of them simply did customary marriages in the communities. The boy and the girl married each other with the family there, and everyone celebrated, and there was no government interference, not regulated and not archived in a registry. So, a two-tiered marriage system. Next slide, please. We're coming up to what's going to be the most interesting part of this. Okay, next slide again. So this is the Babylonian social hierarchy. This is how the law was formed. You had the king and his royal retinue. You had the priestly elite, which included landowners, state officials, temple administrators, and oblates. We've discussed oblates. Oblates still exist today, and so do all these other categories of people. Next were the commoners. They were free, but typically not landowners. So many people in the world today, especially in Asia, may occupy land, but it may be only in a 70-year lease from the ancient imperial title, or it may be some kind of customary title that's time limited. And then at the bottom of the social hierarchy were slaves. Slavery wasn't a permanent situation in those days. It was a situation of punishment due to debt. In fact, if you look at the ancient languages, then if a person is found liable in a civil action, the word for liable usually means enslaved. And that's the condition of liability. So the family name in those days was a privilege of the urban notable class. It signified historical preeminence, legal rights, which today we call legal personality, and access to power. So the lowest level of marriage may not have had a family name. Next slide, please. On to slide 16. Okay, good, 15, thank you. So we covered this. There are elite marriages and non-elite marriages. Now, I'm critically aware of how much time I have. I don't have much time left, so we're going to speed up just a little bit. I want to get to the very interesting part for you. Next slide, please. Okay. This is the most interesting part of the laws that regulated marriage and divorce. Now, in those days, and this really didn't collapse in the British common law until about a century ago, a man was married primarily to gather property to himself, and his wife was his property. This is a very unfashionable point of view today. 2 years ago, I published a book called Critical Women's Issues, and one of the chapters was a chapter on the legal doctrine of coverture, C-O-V-E-R-T-U-R-E, coverture, which was the doctrine by which the man owned property in the marriage, including the wife. Now, in the event of the commission of adultery, if the man was the adulterer, then the court will confiscate his property, which is a terrible thing for him because he spent his whole life gathering property and now it's gone, so that's a serious punishment. But how was the woman punished if she was the adulterer? Well, it's just amazing the way they used to do it. The court issued a stigmata judgment. The court stigmatized the woman and said, if the wife, or since the wife has been found with another man, she shall now die by the iron dagger. There is no evidence of any woman ever dying by the iron dagger. But if the court has stigmatized her, and she goes to the marketplace, which is where all rumours begin, as you know, who spoke to which woman and who spoke to which man in the market. That's where the base level of the rumour mill starts. If she's a woman who is known to have been stigmatised, to have died by the iron dagger, it's highly unlikely she'll ever marry again. That was the effect of that stigmata. So she suffered arguably more than the man. I don't know what happened to men who didn't have property, probably the same as today, can't get wives. And if you died by the iron dagger for an adulterous act in those days, probably can't get another husband. Next slide, please. Now, just before we move on to this, although there's no evidence that any woman ever died by the iron dagger, there's also no evidence of any iron daggers in Babylon. However, in the Sumerian era of southeast Iraq, as it is today, in the city of Ur, which is the site of the Epic of Gilgamesh, it's about 7,000 years old, there is an iron dagger. There's no narrative attached to it. There is simply the symbol of an iron dagger. This is what I was talking to you about before, of the nature of archaeological transmission of law in Agadic form. The iron dagger, which was quite a long knife, about this long, maybe 30 centimetres long, it had a narrative attached to it. And the narrative was a narrative announced by the judge in the court, and it had a stigmatic effect on the woman who'd received that judgment. So she was subject to the transmission of an extremely ancient law,
Sorry, Professor.
beyond the archaeological period of 4,500 years.
3 minutes more.
You want me to wrap up now?
You have 3 minutes more.
3 minutes, okay. So I'll wrap up. We won't worry about the PowerPoint. So what we've seen today is 2 tiers of marriage. The elite families have registered marriages controlled by the state, and when they divorce, the divorce is through a dowry system. There's no evidence of any trials for adultery amongst elite families. But in the common, low socioeconomic families, there's a much less documented marriage, unlikely to reach an archive, and there are stigmatic consequences in the law, loss of property or dying by the iron dagger. When the kings of the Babylonian Empire changed, the archives were burnt down, and all these histories of these ancient laws and the people who were subject to them was lost forever. Still happens in our time. There's still floods and fires in national archives when the government wants to get rid of the information. Well, now there we have it. You have customary law, you have religious law, you have transmission through customary law to statutory law in a religious transmission system of the ziggurat, and we can see that cognates of that ancient system still operate today. I hope you've enjoyed this information. That concludes my remarks.
Okay, thank you, Professor Gary, for the insightful perspective. Before we enter to the Q&A questions, we're going to save after the next speaker. And our next speaker is Dr. PG Ismail bin PG Musa, who will be discussing about Islamic legal system and issues and challenges in context of legal pluralism in Malaysia. Dr. PG Ismail, the time is yours.
Which one is right? Assalamualaikum, can you hear me?
Loud and clear.
Yes, we can.
Okay, thank you very much. Assalamualaikum warahmatullahi wabarakatuh. Bismillahirrahmanirrahim. I think my presentation a bit different, quite different from Dr. Gary's presentation, because this is not a lecture. This is about sharing about legal arrangement in Malaysia, especially about the administration of Islamic law in Malaysia. Can I have my slide, please? Okay, thank you very much. But first of all, I would like to express my gratitude to the committee of SRC for inviting me. Inshallah, what I want to say today is not just about my academic research, but it's also about my experience, because before joining University Malaya, I was a Sharia prosecutor for the state of Sabah in Malaysia since 2003 until 2021, and then after getting my PhD, I joined University of Malaya. So I would say this is my research area about legal pluralism, because not just because I have some experience that I want to share with you today. Okay, so first slide, please. Okay, for better understanding about this, okay, we stop here, okay? Okay, thank you very much. To understand better, for better understanding about my presentation today, my sharing today, first I want to talk about the Islamic role from the historical perspective, because Malaysia has historically been colonized by the Portuguese in 1511, I think, if I'm not mistaken, and then by the Dutch, and then by the and then British. Okay, there is a very short time of period occupation by the Japanese from Japan. Okay, and then after the from the historical perspective, I was talking about the current position of Islamic law in our federal constitution. Okay, then we will see why the arrangement for the Islamic legal system a bit different if you want to compare with the other state in ASEAN especially. So we'll understand why the position is a bit different. And then the last one, the challenges. Because when we talk about the legal pluralism, it's a very broad topic. So the challenges today, I want to talk about how to balancing the three legal system in Malaysia, which is the civil system, and then we have the Islamic legal system, and then the last one for the Sabah Sarawak, we have a native legal system which is applied in customary law. Okay, next slide. A simple thing about the before colonial era, before colonial British come to the Portuguese. The first one is the Portuguese come to peninsular Malaysia. Okay, because before the colonization, historically Malaysia, the peninsular Malaysia, there's a Sultan of Malacca, which is there is a nexus between Sriwijaya kingdom with the Malacca Sultanate, and then in the northern we have the influence from the Langkasuka, from the Patani, and then there is several government kingdom which is applying Islamic law. So simply say, before the colonization from the British, Portuguese, Dutch, and Japanese, the Sultan has absolute power in the administration of the country. Meaning to say, there is only one law. There is only one law in in Peninsular Malaysia, which is Islamic law. Okay, during that time, something about custom in Peninsular Malaysia is already absorbed in the Islamic law. There's something interesting about customary law in Malaysia. Even I know we all know this as Negeri Sembilan here in Malaysia. Applied, it's come from the Minang Kabau, so they apply the Minang customary legal system, but the administration of the inheritance, the marriage is settled in the Sharia code. They have none of the customary code in the Peninsular Malaysia. Okay, this is before the British. Okay, next slide, please. Okay, during the colonial, something is very changed the status of the Islamic law in Malaysia is the introduction of the residential system, which is the British control all the power except for the matters of the custom of Malay and then the administration of Islamic law. This is the only thing still in the power of the Sultan. So this is what happened in the British, and then the British come, of course, they introduced the common law. And this happened until now lah. Okay, the next one, please. This is during colonial era. Okay, next. Okay, even in Malaysia, this is still in historical perspective, right? Even in Peninsular Malaysia, they apply the common law, but there is a recognition about the Islamic law. For instance, there is two cases, which is all the students here in Malaysia. In the first year, they learn about Malaysian legal system. They will learn about the Rahman versus Laton, in case of Regina and William, the what decided by the Privy Council, which is simply say Islamic law is not a foreign law; it's a local law. It's always lex loci. Okay, so there's understanding about the status of Islamic law from historical perspective. Okay, next slide. Now come the independence in 1957. Okay, next slide. Okay, this is an issue. Is it Malaysia is an Islamic country or secular country? Okay, because there is a narrative statement from the first our Prime Minister Tun Abdul Rahman, which is clearly said Malaysia is a secular country. Even there is a provision, there is an article in the federal constitution said Malaysia Islam is a federalism. Sorry, religion of the Malay federal. The Malay state. So, but still, the government say it's just for the ceremonial need. Okay, but in reality, we apply the secular value. Okay, and then come to Dr. Mahathir Mohamad. Okay, it's 2001, 2022. Okay, they say Malaysia is an Islamic country. Okay. So Malaysia is not even we're not implementing hudud here in Malaysia, but it still doesn't mean Malaysia is a secular country. That's what from the executive perspective. Okay, next slide. And then this is the position of the Islamic law in Malaysia. Clearly, it said Malaysia Islam is a religion of the federation. Okay, I'm pretty sure there is no part, there is none in our federal constitution state. Malaysia is a secular country, but it's also said there's a human for our student here, even amongst the lawyer, because there is a provision about the supremacy of the constitution. Okay, but the constitution do not put the Quran and Sunnah as the highest authority. By the way, Article 3 and Federal Constitution says very to say Islam is the religion of the Federation, but the religion can practice freely in harmony in the Federation, any part in the Federation. Okay, this is the status of Islamic law, and then we'll see the continuation from the practice of the residential system during the colonial, which is Sultan still have the absolute power on religious matter, Islamic matter in the custom of the Malay in the Peninsular Malaysia. the dominant, I will say the dominant, the dominant, I don't want to say native, but the dominant native is Malay, because there is a certain interpretation about native, about Malay in the constitution. Okay. So the next slide. Okay. This is from the perspective of, if you from the slide earlier, we're talking about from the perspective of the executive, from both Prime Minister, which is the Rahman, or from Prime Minister, and then we have a statement by the Tun Dr. Mahathir, or I think fourth Prime Minister, and then the eighth Prime Minister, I forgot, because something happened in the after 2018. There's a lot of Prime Minister, and then there is a two case. How to define the Article 3 in the Federal Constitution. Okay, Chairman, so it's very famous case among my students here. Okay, this is clearly said. Even there is in Article 3 said the Malaysia Islam is religion of federal, but still it doesn't mean we have to apply Islamic law. But because what? Because we still in this case it been decided that we still hold the value of the secularism. Okay. And then come the Lina Joy case. Lina Joy case is about apostasy. Chairman saw about the about drug trafficking. Okay, and then in the Lina Joy cases, they will say the Article 3 is that the Islamic, the dominant religion, federation being the main dominant religion, the federation have the duty to protect, defend, and promote the religion of Islam. So we know. Even the decision from the Chairman so said Malaysia is the article says that it doesn't mean Malaysia is Islamic law, but there's no one can deny that Islam have a special position in the federal constitution. Can you slide please? I try my best to show my my slide because I really want to comply with the time limit. Okay, next slide please. I think this is the role of Sultan in uploading Islamic law in Malaysia. There's nothing new. Okay, next. Okay, I think next. This is the definition of the Islamic Malay. Okay. Now we come to the jurisdiction. Now we're talking about legal pluralism. The arrangement about legal pluralism. Okay. We know Malaysia have a good product in Islamic banking. We have a halal procedure, it's a very good halal procedure, which is well known internationally. But those things not fall under the jurisdiction in Islamic law. Why? I mean, the Sharia code, because this is under federalist. Okay, so everything about banking, everything about halal is governed by the federal law, by the act. So it's not. If there's an argument, it will be settled in the civil court, not in the Sharia court. So what is the scope of the legal pluralism in Malaysia? Remember, we're talking about legal arrangement. Okay. Now, the only thing that's under the jurisdiction of Sharia court is mostly in the family matters. Family matters, we can say in my slide, and then we have some kind of administration matters and some kind a bit about offense, the prosecution offense for the person possessing of Islamic for religion of Islam. Okay, next slide. Okay, so in short, this is the ingredient, the essence of the Schedule 9 of the Federal Constitution. The family matters, Islamic law offences. Okay, Islam did not contradict with the Federalists, and then administration of Islamic property. So administration of Islam. This is administration Islamic law for the zakat, for example, the zakat, and then wakaf. But the banking, about Islamic banking, is not fall under the jurisdiction of the Sharia court. Okay, next slide. Okay, this is something interesting about Malaysia. Okay, so in short, we have three courts in the we call it a personal matters. Okay, personal matters, which is native court, which is governed by the Sabah and Sarawak. And in the Sabah and Sarawak, this is focused on the customary law for the non-Muslim. Then we have the Sharia court. Sharia court, we just discussed the jurisdiction, and then we have the civil court. So, for example, okay, now for the native court, there's the provision in the constitution. Okay, and then long short story for the native court. Native court is personal law for Sabahan and Sarawakian. Doesn't have to be I will explain later. And then for the Sharia court, it's focused on the personal law for the Muslim, and then the rest is under the civil court. Okay? Next slide. Okay, this is something important about the administration of the Islamic law here in Malaysia. The amendment of Article 121(1)(a) for the Constitution. Okay, before the amendment, the civil court always interfere with the decision of the Sharia court. For example, there's a case about the legitimate child. Okay, because in Islam there's a presumption of law which is if the child born within 6 months of the time of marriage is considered as illegitimate. Okay, so there's a case which is decided by the Sharia court, but the parties go to the civil court, and then the civil court overturn the decision by the Sharia court, and then they follow the Evidence Act 1960, which is it doesn't matter for how long, as long as there's a marriage, so it's considered which is against the Islamic perceived. Okay, so that's the purpose of the amendment 121(1)(a). Okay, next slide. I think we next slide. Okay, this is some cases. The first before the amendment, Nafsi Abdul Majid. This is why, which is the case decided by this is the breach of promise of marriage, which is when the case brought to the civil court, the court decide this case based on the contract. Okay. And then Bagian along Muhammad Arif, this is the custody. And then the next slide. Okay, this is Sharia court after the amendment. Okay, next slide. So the point is the spirit of the amendment of the Article 121(1)(a) to give the exclusive power to the Sharia court to decide, to hear the cases under the fall under Schedule 9 Federal Constitution. I just show you earlier. So there's no longer try to overcome the clash between the Sharia court and the civil court. Okay, that's the purpose, the spirit of the amendment of Article 121(1)(a). For the further reading, you can read the case of Dato' Talib versus Muhammad Habibullah bin Mahmud. Okay, next slide.
You have 3 minutes.
Okay, this is Article 121(a). Yes? Okay, this is Article 121(a). Okay, I think this is something I just mentioned here. Next slide. Okay. Because of the time constraint, okay, just next slide. Okay. Now we're talking about legal preservation, interaction between the Sharia court in Malaysia and the other courts. Other courts mean the civil court and the native court. Next slide. Okay. The first one is the custody. The custody. This happened after the dissolution of marriage. Okay. For example, the case Indira Gandhi. Before the Indira Gandhi, we have a Subhashini case, which is the case about the unilateral conversion of child. Because this is how the court of federal court interpret the word of parent under Article 12(4), which is under the case of Subhashini. The parent, since there is no S, Okay, so Mahkamah, the court decided the words refer to the singular, okay, which is either the consent either from the father or the mother. It doesn't have to be combined of father and mother. But in this intragani, something happened. The court decided the parents means plural, means the consent must be obtained from the father and the mother before the registration of the conversion to Islam is valid. Okay, this is under the first issue is custody, unit to conversion. The next one, next slide. Okay, next alien cases. Okay, this is for the criminal because there's some jurisdiction clash between the Sharia court Sharia court and the civil court and the penal court. For example, this is sodomy, which is liwat in the, I think in the Malay language is liwat, even in the Arab we call it liwat. So it's against, it's a contradict with Section 28 of the Selangor Criminal Offences, Sharia Offences, and contradict with the Section 377A of the Criminal Code. So it means because of this review by the federal court, so the section 28 of the Sharia Criminal Offences is ultra vires in Malaysia. Okay, next slide. Okay, the declaration of religion. This is case Rosiza. Still, even maybe I forgot to tell that there is an issue how to define which part it is. How can the Constitution bestow the jurisdiction under the Article 121A? Either the jurisdiction must be explicitly stated in this written law or implicitly. Okay, so the current decision is implicitly. So in the case of Rosiza, before the case of Rosiza, all the matters about the apostasy, about the declaration of the religion must be the declaration must be obtained from the Sharia court. But from the case of Rosiza, in case of Muslim ab initio, non-Muslim ab initio, the person can go to the civil court for the declaration of the Muslim. Okay, next slide. And now we're talking about the interaction between Sharia court and native court, because native court in Sabah and Sarawak still the native court, the law is native for the Sabah and Sarawak, customary law for the Muslim especially. But there is for the overcome the conflict between Sharia court and the native court in Sabah and Sarawak. There is a provision in the native court which is the native court shall have no jurisdiction in respect in cause. Okay, the problem is there's a legal maxim in the native court which is adat is adat, is nothing to do with the religion or in Malay. Adat bukan adat, tidak ada kaitan dengan agama. This I will say this is the native legal maxim, which is very give a broad definition of the section 9. So until now, why there's certain cases for a Muslim can be brought to the native court. So something I think ourselves to think about how to overcome this problem, because it could lead to double jeopardy maybe, and then there's some issue, some interreligious marriage, which is absolutely not allowed in Indonesia. Okay, next slide. I think that's all for me. Thank you very much. Sorry for the bit. But inshallah, after this, if you want to discuss more about the presentation today, you can email me. And then, okay, thank you very much to the committee. That's all from me.
Okay, thank you once again, Dr. PG Ismail bin PG Musa and Professor Gary I. Lilienthal, PhD, for guiding us through this challenging terrain. From what we heard from Professor Gary, ancient Babylonian law was far more than a set of private contracts. It was a powerful tool for shaping society itself. And marriage law itself reflected and reinforced class hierarchies, distinguishing the elite from commoners not only through wealth, but through the very language of the law. And also we've learned from Dr. PG Ismail that Malaysia's legal system is a unique model of legal pluralism, where Islamic law, civil law, and native customary law coexist. And Dr. P.J. Ismail reminded us how Islamic law in Malaysia has deep historical roots, evolving from pre-colonial sultanates to its modern constitutional positions. And now, the conversation shifts to you. I will open Q&A sessions for 20 minutes. If you have any questions, you can raise your hands, both in offline and online. Is there any of you want to ask more or discuss more about the presentation from Professor Gary and Dr. P.G. Ismail, sorry. Maybe I will read the question from the chat box in the Zoom. Assalamualaikum warahmatullahi wabarakatuh. My name is Oci Sanjaya from Faculty of Law Singapura Bangsa Karawang, and I have question from Professor P.G. Ismail. How are the criminal law regulation regarding the protections of children who are victims or perpetrators of sexual violence crimes in Malaysia? Are there any difference between the general criminal law regulations of the Malaysian Criminal Code, or are they regulated by lex specialists specifically? Thank you.
Can I answer now, Ms. Benedetta?
Yeah, maybe you can
Okay.
answer the question directly.
Okay, thank you for the question. Yes, in Malaysia, we have a special law for the child, especially in the sexual offences. I'm not sure. The Child Act 2001, we can refer the Child Act 2000. There is a special act for the matters in the how regulating the trial, the protection. Even the trial is different from the ordinary people. Okay, the ordinary person. So yes, there is a regulation, special regulation, the special law for to protect the children, even if the children is the perpetrators. Okay, but still there's a certain procedure which is fall under the Child Act 2001. I hope this could answer your question.
Okay.
Thank you, Professor.
Thank you very much.
Okay, we still have time for the Q&A sessions.
Can I have a question for directly to the board speaker? Okay, good evening, everyone. My name is Vishnu Satya. I'm an independent researcher for Religous resolution, talking about ocean and coral conservation. I have specific question to Dr. Gary and also Dr. Ismail. For Dr. Gary, I actually wanna dissect deeper into how an anthropology can also become a tool to look after the several customary law, particularly for example, in law that governing in a society. Like for example, in Indonesia I have an adat law and also Islamic law that actually coming hand in hand, but also had several conflicting authorities. For example, if you are talking about Islamic law in Indonesia, we are not really an Islamic state, but there are living law that one of them is an Islamic law. So how can an anthropology become a tool that can separate between a living law and law that actually coexist before them? Because I think it's become one of the important questions when we are trying to see the balance between Islamic law and other law in Indonesia, because we have still struggle to adapting the added law into like a living community, because several regulations that we have actually acknowledge traditional knowledge, but also lacking in enforcement in the court. And how can anthropology can answer that question in legal doctrine manner? We should actually uphold more on the living law, which is the other law, or we should actually balancing between other law and Islamic law, for example. And my question to Dr. Ismail is more likely like a comparison between an Islamic law in Indonesia and also in Malaysia, because I've seen that several Islamic law has been enacted in Indonesia, for example, for halal certification, and also for a some like economic Sharia or Sharia economics. We have a banking system, but for a penal code, or maybe not informed like in perdata court, in penal code, we only had Kanun Aceh in Aceh Darussalam that actually adopted a penal code from Islamic law, which is the hukum cambuk, Pak, if you know. If someone commit adultery towards, if for example, if a wife commit adultery to the husband, they can have a hukum cambuk, but it's only in Aceh. Yeah, not only in not on other region of Indonesia, but my question would be is actually Malaysia do that penal code more intensively on the matter, or are there is also specification for the penal code to be conducted in a national way, or according to the not according to Islamic law, or just simply only according to Islamic law? Because you already said before on your presentation that the federation is actually promoting Islamic law into a higher hierarchy, right? So is the penal code actually do the same when it's come to a penal code specifically? Thank you for the time, and please answer it so I can read it correctly. Thank you.
Shall I answer first?
Yeah.
Yes, please.
Okay, I think if I understand that very long question correctly, I can give an answer that will help. In ancient Babylon, the judges dealt with all matters of law, including customary law. As I said, that in ancient times, as Cicero said, customary law, in the absence of a statute, has the force of a statute. And that's the way it was judged at times. Now, I live in Australia, which is a British common law system. It's not the same as Malaysia. The Malaysian version of the British common law was introduced by statute, and that has different effects. The British common law in Australia was introduced in 1828 by charter, and it's arguable that it's never been properly introduced and can be removed very easily simply by ignoring it. There's nowhere in the Constitution that says that the British common law should apply. But, however, having said that, 1828 was introduced by charter. Throughout the 19th century, the British common law courts did their very best to stamp out customary law. And they really did stamp it out, and it arguably became adjectival law. Two of the surviving forms of customary law are in the law of divorce. Divorce used to be a criminal act, the common law, but now it's been decriminalised some time ago. And all that remains of that now is the Briginshaw and Briginshaw case, where derived from the law of adultery, so that the more serious the civil issue, the more closely the evidence has to be looked into. So fraud, you need much more probative evidence than you need for a breach of contract. That's the Briginshaw and Briginshaw case. The other area where it survives is in adverse possession of land. Dr. Ismail probably has the same situation in Malaysia, where somebody's been living on the land for 40 years but does have legal title. So the court will look at what's called colour of title, which is a customary issue. And in colour of title, it means he thinks he owns the land and all the neighbours think that he owns it too. And if that's the case, that's the first stage towards a legal declaration of title. Now, having said all that, I want to tell you about the how hard they worked in the British court to stamp out customary law in the 19th century. There was a case, so I call it the cannibalism case, but it's a case in the criminal law that demonstrates the criminal defence and the criminal excuse, two things, defence and excuse, one's different to the other, of necessity. And a number of people were stranded in a rowboat 1,000 miles off the shore of Britain, and they thought they had no way of reaching the shore. And the young cabin boy from the boat was apparently ready to pass out. He'd drunk some salt water. There was a maritime custom in those days that you could cannibalise in those circumstances the weakest person and eat him and drink his blood in order to stay alive. Now, the judge, Lord Coleridge, constituted the court in an arguably improper way, a completely different way than it would normally be constituted. We won't go into details, but you see this all the time on committees where they improperly constitute a committee so they can get the decision they want. And he said that he actually found men who ate the cabin boy guilty of murder, even though custom allowed for it. However, they were rescued. Somehow they were rescued and they were brought back to shore in England. And there was a major outcry. The people said, we won't tolerate finding these people guilty of murder. After all, it's a maritime custom, and we're very happy to have our homes back again from their terrible ordeal, and we don't want them going to jail for murder. And the Crown commuted the sentence. So the court tried its very best to stamp out the custom, and arguably did, because nobody pleads that custom anymore, although I can't really say people are stranded too often on the high seas in rowboats in these days and eat cabin boys. You don't hear about it, do you? And but there was another methodology that the Crown used, arguably the power of pardon. So does that answer your question? Are you satisfied with that? Your question was very long, so I had to categorize it myself.
I'm sorry for the long question, actually, but I just answer my question because I do want to have a clarity on the intersection between the living law and the practicing law. Thank you. Thank you so much for the answer.
Okay.
I think it's my turn, right? Okay. Still, for me, it's a bit a long question also. Okay. What I understand you're talking about the administration of the criminal law, comparing Malaysia and Indonesia. Okay. Because there's a to set in the Sharia code there's a Sharia offences which is the maximum punishment is 6 caning, and then not more than 6 caning, and then the 5,000 ringgit for the fine, and then for the imprisonment about for the Sharia. And then there is under the civil code, which is a penal code, and there's another law which is can subject to the Janayah, right? The criminal, which is so the penalty is the death penalty, which is the capital punishment, which is until now this is not mandatory penalty, and then whipping, the government towards to abolish the mandatory whipping. They want to give the option to the judge either want to sentence with the whipping or not, and then the fine. This is the penalty in the civil court. Okay, so. Actually, in the Malaysian context, why this argument either Malaysia is a secular country or the Islamic country? This is at least my argument, because there is no one piece of law in Malaysia which is against the principle of Islam. Okay, when I talk to the student from the Pinagoro, from the UDM, what's happening in the Genting Highland? There's a casino, right? There's a casino, but even there's a casino, but there is a restriction for the Muslim. For the Muslim, you cannot enter not the Genting but the casino for gambling, for any activity of gambling. So which means this is about the freedom of the religion. So it's up to you. It's up to for the non-Muslim. They want to if they attend to gambling, so there's nothing problem in the law. For the Muslim, there's a restriction for the liquor, okay, even consumption of the liquor, gamblers, so there's a restriction. That's why my argument why the law is actually a bit aligned with the Islamic law actually, because we have no any LGBT marriage, we don't recognize LGBT marriage, we don't have any interreligious marriage for Islam, for the Muslim, and then maybe I don't know. Maybe this is a bit elaboration about what happened in Peninsular Malaysia, which is I said that all the Malay custom decided by the Sharia court, because the custom itself in Islamic law considered as a source of law. As long the custom is not contradicting with the some recall about the usul, meaning the principle of Islamic teaching. So, for example, if like a Minang, right? Like a Minang, so this is nothing about against the principle of Islamic law. So yes, it's considered Islam within the Islamic law. That's why they can decide by the Sharia court. It's different from the Sabah Islam because there are a lot of communities which is non-Muslim. So this must be a special court for them, especially for the Kadazan Dusun. There must be a special court for in terms of this legal survivalty. Okay, I think it's all for me, Vishnu.
Thank you, Dr. Ismail, for the answer.
Okay, thank you again, Dr. PG Ismail and Professor Gary for the answer. Maybe if there's any available question in the chat room, you can answer the question in the chat room too. Okay, please give applause to our speakers, Professor Gary and Dr. PG Ismail. Okay. And now we move to the session 2. And our next speaker is Dr. Bhupinder Singh. And he will present on exploring clinical trials for anti-aging medicines in digital health sustainability, legal measures for longevity promoting food supplements, and medication in public health. To Dr. Bhupinder Singh, the time is yours.
Thank you so much. Thank you, and a very good morning from India. And I am thankful to the organizing team as well as Professor Evie for providing me this wonderful opportunity to share my views on exploring clinical trial for anti-aging medicines in digital health sustainability, legal measures for longevity, promoting supplement and medications in public health in the second international conference. So. I start this with the concept of the healthcare, which is very significant, as well as we are using the technological aspect in this particular healthcare with the help of artificial intelligence, and from this diagnose as well as recovery management and personalized treatment and other things are there. And globally, this also pursued with this the global healthcare landscape also there. And this digital health solutions explore every aspect of this healthcare delivery, revolutions as well as what are the long standing challenges are there. The convergence of this technological aspects are also there. And with the help of all these, we have the pluralism concerning positions for this patient-centered future here. So with this, the AI is playing here the important role in this healthcare ecosystem, where we have this the analysis of large database, whatever the database belongs to the patient here, the pattern and providing actionable insights for both clinics and the patients. So, in this scenario, the use of artificial intelligence for recovery management, for data analysis with the help of blockchain technology, the improvement in the public healthcare is very important from national, from international own sites as well. So these kind of aspects like in diagnosis, we have the AI algorithm where they are using to cross-check with the patterns as well as the abnormalities in the scan, including cancer, fracture, and other kind of pathogens. So the application of this artificial intelligence is from simple recovery management to what about the critical situation in the healthcare things are there. So we have the AI power tool such as wearable device. We are all majority of cases we all are using smartwatch, smartphone we have, and telemedicine platforms and healthcare professionals to remotely monitor the patient health and the intervention productivity as well. So this RPM, the remote patient monitoring, is like there is a managing the aspects like diabetes, heart disease, respiratory conditions. So these technologies continuously gather the data, whatever the positions concerning the outcome as well as the reduced hospitalization rates. Because for the checkup, for at this stage, there is a free involvement is there. But in case with the help of technology, they proceed with this remote patient monitoring. It at least reduce the traveling cost. It also reduce that the efforts as well as the time and the benefits are there which pass on to the patient. So across the globe, the effective healthcare management and its delivery is very significant concern, and the government maintain the infrastructure, generate new infrastructure for providing healthcare facilities for the people around the globe. And we have the significant advances in this, the delivery of healthcare for all the population, irrespective of their economic status, because it's a basic human right, and these concerns things are important when we are concerning with the proper healthcare checkup as well as what about the provisions concerning this anti-aging drug clinical trials as well, and which desire to increase the duration of life. Same way, the healthcare and alleviating age-related illnesses as well. So these the kind of the general sciences as well as the momentum in all these kind of things are there, and but still we have this multiple kind of challenges are there, like aging is a multi-dimension. It's not only you can say go with the one single aspect. It's about your dietary habits. It's about your exercise, your daily routine life. What about your mental pressure? So these kind of multiple aspects and things are there which are directly dealing with this the anti-aging concept. And with this, we have this by 2050, the almost 22% it's the data availability that the population will be above the age of 60. So, from public health perspective, how we can go with this so that the people can remain healthy, as well as the challenging situations are there, obviously. But how to protect ourselves from any kind of communication, as well as those kind of things where directly hamper your healthcare. As per the WHO, we have the health. They specify as it's a physical health, mental health, spiritual health. It's not only about the absence of disease. It's about your continuous health, which is free from disease, as well as your optimum level of good health and well-being. So when we understand this anti-aging food and medicines and supplements, then the anti-aging pharmacy as well as the supplements are rapidly growing market in this modern healthcare. So this growing market in this modern biomedical advances and a growing interest among the general public in this living longer and healthier lives. So these kind of approach include the dietary supplements as well as the countering the biological aging as well as preventing the disease and optimizing this quality of life. So the concepts like this pharmacological as well as the lifestyle approach with the help of artificial intelligence and the other technological aspects are there. Like the lifestyle measures where we have the positive and the negative aspects are there, and balanced nutrition, regular physical activity, how you manage your stress, and proper sleep always as main the key intervention to promote health span and reduce the burden of age-related disease. So this slide where it contains the multiple aspects or dimensions are there, and with this we can reduce the burden of age-related disease and it help out to maintain that optimum level as well as your healthy life. So, what about the clinical the design methodology and the considerations are. So the clinical trial is an integral part of this medical research, responsible for assessing the safety, proper use of newly developed medicines, therapies, and medical devices. So these different designated scientifically sound studies are there, which performed on the human subject and which also need to address the multiple questions are there. But so, what about this public health implication of this anti-aging clinical trial? We have the provisions concerning how we extend the lifespan as well as moving that health span, have the healthcare implementations are there, and these multiple implementations as well as the health implications from this throughout the globe, as well as the therapists and other kind of reasons are there, which prevent at least kind of those kind of disease, which may be a communicable disease, which may be a non-communicable disease as well. And these collaboration across the discipline is required, where the establishment of the international standards, we have the World Health Organization, we have the protocols, conventions, declarations are there, and the clinical trial and safety protocols also advances the treatments as well as the intellectual property landscapes where the invention of the new drug as well as the testing of the drugs on the human being, and what about its distribution, pricing, public health strategies. these all in a collaborative manner help out for the different scientific and societal dimension of anti-aging research. So here at national level, we have the provisions concerning this AI with the media as well as the legal aspects where the rules, regulations, and the amendments are there. And international level, we have the international aspects concerning the health insurance productivity as well as the Accountability Act and General Data Protection Regulations. So this HIPPA and the GDPR, these two regarding regulating the aspects concerning artificial intelligence as well as the privacy of the patients and the rules mandates from the administrative aspects are there where they try to protect the sensitive health data, promoting transparency, accountability, and the trust where we are using this AI technologies in this digital health platform. Because right now, in case anyone go for treatment in a hospital, then along with the that particular data where the protection is really important and it's on the part of the hospital organization and how they will proceed with this the protection of your health data at this particular digital health platforms. So this the study of this public health the required identification of the various sector, and we also see these kind of things in this COVID-19, where the public health expert playing a really important role in all these different spheres, and it increased the focus on this public health as well as the disease prevention, where this public health care and disease prevention are the main concern of at that time of all the governments across the globe, and multiple factors as well as the notifications, guidelines issued by this World Health Organization at that time, and the provisions concerning this the relevance of this medicines really important at that particular point of time, and what about our level of achieving this hygiene and the nutrition from that particular angle is really important, and this food and medical assistant food which is free from any kind of pesticide as well as the organic food we as supposed to consume, and the medical assistant whatever maybe from the private sector or from the government organization it required, and these multiple dimensions belong to a good healthcare. How you proceed with your daily routine life activities, your exercise, your dietary pattern, your work life balance. These all important variables for the human healthcare. What about your level of awareness? What you eat? What about you choose your the activity or the task, but as well as the health infrastructure which is available from the government as well as from the private layer. That disease screening again is really important because in case we can prevent, it means there is less requirement of that particular infrastructure for to cure that particular concept, because we believe in the concept of the prevention is better than cure. So on these aspects, we have this population factor and effective medicines also required for this particular concept. So how to maintain this particular global health care, specifically when we are talking about the anti-aging and the legal measures, then the medical facilities, food, global legal provisions, the national legal aspects are there. And for this, we need to proceed with the healthy food, regular workout, medical checkups, and implementation of the global and national legal provisions, because the legal aspects are really important, along with going with these other kind of social as well as your personal health care. And we have multiple challenges in the healthcare, like what about the availability of infrastructure, the availability of hospital, the availability of the staff, the availability of the medicines. These all things belong to this, the availability. Next is we have the accessibility. The accessibility again remains a challenge here, where with this, the concept of accessibility here is about the purchasing power, how you can achieve this particular, the accessibility to take care of the health of anyone. Affordability is again a challenge for somehow the population maybe not able to afford this particular the system of as well as the services of the healthcare. And the quality again really matter, because in case we have the generic medicines kind of concepts are there, and the hospital and other kind of services are not good, then how anyone can achieve this particular quality of healthcare as well. The specialization of the services, like the specific requirement of the healthcare, ambulatory care and the emergency treatment kind of things are also belong with this, the challenges in this particular healthcare system. Now, how we can measure, how we can address, these are the indicators belong to the healthcare. So, the exercise, where mostly the people simply proceed with the daily routine life without doing this. Regular medical checkups are also not there. Lack of implementation of law, the legal provisions, healthcare infrastructures, food security and malnutrition, and infant mortality rate. The important and the larger one, we have the infant mortality rate, where it hamper directly on the healthcare belong to each and every kind of aspects are there. So this is about provisions about the background. I simply skip that. We have the provisions at global level, like the International Labour Organization. We have Food and Agriculture Organization, where to eliminate hunger, food insecurity, malnutrition. UNICEF, the important role here for the healthcare, for the well-being, for the care of children. And we have WHO, where the leadership in healthcare, fostering health security, strengthening health system, also required in this particular concept. And along with the organizations, we have the declarations and the conventions are also there. The UDHR 1948, the provisions are the specific provisions for the male, female as well as for the children. And we have the provisions from the sum of our world constitution as well. These are the provisions from this India and perspective, but basically the multiple kind of aspects and other things are there. But how we can go with this personalized medicine, which is really a important shift, and with the help of AI technology, we can simply unlock that potential of personalized healthcare, moving healthcare away from this all size fit approach. And this AI can identify the pattern in the individual daily routine life, lifestyle, environment, personalized treatment plan. With the help of AI, we can move forward. And the provisions concerning this public healthcare and the disease surveillance, AI is playing very important role here. And which also going with this telemedicines, And the data security and ethical considerations also required when we are talking about this, the use of technology in this healthcare, because the cyber security measures really required, because somehow we need to maintain a balance of what about the healthcare data as well as the technological interventions are there.
Sorry,
So
doctor, the time is over.
all these kind of aspects in the age of this technology represent the accessibility, affordability, as well as the patient-centered care,
Sorry,
which
doctor.
was lacked at that time. But now, with the help of artificial intelligence, we
The time
move
is
forward
over.
with this anti-aging medicines, as well as providing the personal treatment, the healthcare facilities to the general public, and this AI continue to evolve, as well as it also proceed with this the concerns regarding this global healthcare. So we have the findings where uh, because of earlier the quality of care was not there, nutrition level was very low, hospital clinics were insufficient, and the lack of enforcement of all laws were there. But we have the valuable solutions are also there, and with this valuable solutions we can also go with this the concerns regarding the healthcare and the provisions for these aspects and other concerns regarding this the remedy and the implementation of law. So with this, thank you so much again, and I really respect to Professor Evie, which provided this wonderful opportunity and all the organizing. Thank you so much. Thank you.
Okay, thank you, Dr. Govinder, for the presentation. Very insightful. And for last speaker, but not the least, is Dr. Eka Ardiani Putri Mars MH, who will be discussing about international legal cooperation in global health. Dr. Eka, the floor is yours.
Thank you, moderator. Izin Prof. Garuda Wiko, Rektor Universitas Tanjungpura, dan tamu undangan. Maybe can I speak with bahasa? Yes, okay, thank you. Sebagian tadi sudah disampaikan saya rasa oleh pemateri sebelumnya, karena tentang anti-aging juga dan nutrisi. Slide please. Dan saya akan menyampaikan tentang International Legal Cooperation in Global Health, Nutrition, Pregnancy, and Stunting Challenge in Asia Future Health Resilience. In here, the burden of malnutrition in Asia, kita bicara tentang kesehatan.
Slide-nya belum ada, Bu.
Kita bicara tentang nutrisi di kalangan ibu hamil, nutrition for pregnancy. Di Asia, angka gizi, angka maternal and child nutrition in Central Global Health Development itu memang masih sangat kurang, yang mengakibatkan kematian ibu dan balita di Asia, khususnya Indonesia, India, itu masih sangat tinggi. Nah, ya yang ingin saya paparkan itu adalah sebenarnya Oke, terima kasih. Next slide. Nutrisi, oke. Nutrisi untuk ibu hamil maupun kepada anak-anak, child stunting, itu sebenarnya bukan hanya tugas kami sebagai para medis, sebagai dokter ataupun perawat, tapi ini tugas bersama government, pemerintah yang ada, baik itu khususnya mungkin di Asia ataupun di dunia. Bagaimana sih tadi mungkin disampaikan oleh pemaparan oleh Bu Venus Things, nutrisi ini memang sangat penting untuk diketahui oleh masyarakat. Mungkin ini yang harus diedukasi. Apa sih next slide? Apa sih sebenarnya? Oke, ya oke. This is central pillar global health. Apa sih sebenarnya karbohidrat, nutrisi, protein for the pregnant or the children. Poin ini yang biasanya masyarakat people mereka tidak mengetahui tentang apa itu sebenarnya karbohidrat ataupun nutrisi penting untuk ibu hamil ataupun anak-anak. Contoh sederhana. Jadi ada satu masyarakat, kumpulan masyarakat di sebuah wilayah. Mereka menyampaikan gitu, waktu pas saya tanya, Ibu ini anaknya bagaimana, kenapa anaknya gemuk, fat, tapi tidak terlalu tinggi, is the short body. Why? Because so many karbohidrat untuk dikonsumsi oleh penduduk di satu tempat itu. Oh, anak saya makannya ini loh dokter, katanya anak saya makannya sehat. Ada dagingnya, milknya, sudah ada nasinya, sudah ada karbohidratnya. Tapi ternyata masyarakat di satu daerah tersebut mereka pesta karbohidrat tadi gitu. Jadi anaknya gemuk tapi pendek. Nah itu yang terjadi. Terus yang dimakan apa? Nasi, kentang, rice, potato, pasta, ya kan? They make a soup from pasta and potato and eat together. So the family party karbohidrat party. Jadi benar-benar makan yang semuanya serba karbohidrat, tidak ada proteinnya, tidak ada nabatinya, tidak ada dagingnya. Itu yang terjadi. Nah, jadi anak ini yang terjadi dengan masyarakat kita. Terus bagaimana dengan ibu hamil? Bagaimana dengan kondisi wanita yang istilahnya membutuhkan nutrisi lebih? Vitamin yang dikonsumsi oleh ibu hamil pun itu masih sangat kurang, dan mereka tidak tahu apa sih sebenarnya kebutuhan saat di trimester 1, di trimester kedua, dan trimester selanjutnya. Nah ini untuk pengetahuan awam, untuk masyarakat awam. Oh ya udah, yang penting makan banyak. Untuk ibu yang mengalami kehamilan, ini yang penting makan banyak, makan 2 kali lipat. Ini juga akan berbagi dengan anaknya, berbagi dengan janinnya. Nah, kenyataannya padahal dalam ilmu medical, dalam ilmu medis, makan yang dibutuhkan itu adalah nutrisi yang penting. Jadi bukan makannya ibu hamil itu 2 kali lipat, tapi benar-benar dilihat. Oke, terima kasih. Ini untuk slide SDGs. Menyampaikan bahwa zero hunger, maksudnya tadi jadi mengetahui apa sih yang harus dikonsumsi oleh ibu hamil di semester 1, di semester 2, semester 3 pada saat kehamilan, pada saat pregnancy. Pertumbuhan anak di dalam kandungan menentukan gizi pada saat anak lahir, dan apa yang dikonsumsi oleh ibu hamil itu juga mempengaruhi tumbuh kembang dan mengerti akan apa yang dimakan oleh anak setelah lahir. Nah, saat ibunya fiksi banget untuk memilih makanan-makanan yang harus dikonsumsi saat hamil otomatis pada saat kelahiran anak-anaknya akan menjadi memilih makanan yang dikonsumsi saat mereka tumbuh. Padahal anak-anak yang dari awal saat kehamilan ibunya bisa memakan apa aja yang layak dikonsumsi oleh ibu hamil. Nah, ini menentukan nanti anaknya bisa nih makan atau mengkonsumsi makanan apa aja yang terkandung dalam gizi-gizi lengkap. Di Indonesia, pemerintah kita sudah menentukan isi piringku itu program yang khusus untuk menentukan jumlah takaran karbohidrat, protein, dan juga buah-buahan di dalamnya. Oke, dari SDGs yang kita ketahui, dari SDGs yang kita ketahui. Di sana juga menyampaikan bahwa zero hunger and good health. Good health maksudnya adalah program yang sudah ada dari WHO dan UNICEF memastikan bahwa masyarakat di Indonesia, di dunia, di Asia itu memastikan bahwa anak-anak yang lahir itu sesuai dengan tangga pertumbuhannya. Tangga pertumbuhan anak di saat usia awal usia awal kelahiran dari 0 sampai 1 tahun, 2 tahun hingga 3 tahun sampai balita itu memang merupakan angka usia emas untuk anak-anak bisa mengkonsumsi makanan dengan mikronutrisi yang penting untuk kesehatan mereka. Berikut stunting prevalence range from 26% and 33% in South Asia. Next slide. Nah, anemia and underweight. Anemia dan underweight pada ibu hamil 1 sampai 3 trimester kehamilan. Ini yang merupakan angka penting yang kita dari teman-teman medis itu berharap diinformasikan kepada pasangan usia subur atau wanita usia subur untuk mengetahui sejauh mana sih harusnya idealnya berat badan setiap ibu yang hamil dan seberapa banyak pertambahan berat badan saat kehamilan. Kenyataannya dengan saat ini yang sudah mulai banyak wanita-wanita menjaga berat badannya harus sebenarnya di bawah underweight. Ini yang menyebabkan bahayanya ke janin atau pertumbuhan anak. Oke, selanjutnya tentang suplemen tadi ya. Suplemen yang diberikan kepada ibu hamil itu memang hanya yang mereka rutin untuk datang ke layanan kesehatan. Untuk yang tidak jarang datang ke layanan kesehatan, nah ini yang kita mungkin agak sulit ya. Bagaimana sih sebenarnya aturan untuk rutin mengkonsumsi vitamin agar pertumbuhan tinggi badan anak itu sesuai dengan yang kita harapkan, sesuai dengan usianya. Faktor yang utama itu sebenarnya selain makanan atau gizi pada anak adalah faktor air bersih, faktor ekonomi, dan juga faktor lingkungan. Mengapa? Air bersih yang masih sangat sulit saya rasa didapatkan ya, terutama masyarakat yang tinggal di daerah perifer Indonesia, di Asia juga, air bersih itu masih belum dalam level yang memang aman. Yang diketahui oleh masyarakat adalah air yang tidak berasa, tidak berwarna, tidak berbau. Padahal dalam dunia kesehatan, standar kesehatan air itu ada tambahannya lagi, yaitu air yang mengandung pH normal dan juga tidak mengandung mikroorganisme. Jadi sebenarnya dalam air yang sehat itu tidak hanya tidak berwarna, tidak berbau, dan tidak berasa, tapi juga dalam pH normal dan tidak mengandung mikroorganisme. Mungkin kita bisa lihat ya di bagaimana sungai-sungai yang ada saat ini dan bagaimana konsumsi masyarakat yang masih membutuhkan air sungai ataupun air sumur yang tadi yang tidak sehat. Nah, selanjutnya lingkungan. Kita bicara tentang lingkungan. Lingkungan yang tidak kondusif untuk tumbuh kembang anak, lingkungan yang memang kurang untuk misalnya contohnya adalah anak yang kurang diajak menerima udara yang bersih karena rumah yang padat penduduk, populasi yang sangat padat, sehingga dalam lingkungan tersebut tidak ada ditumbuhkannya pohon. Nah, dari wilayah tersebut udara yang kurang bersih, belum lagi lingkungan-lingkungan yang memang masih belum layak huni. Ya, nah itu juga yang biasanya kami butuh untuk pemerintah maupun teman-teman dari bidang lain untuk ini sama-sama PR buat kita bersama. Jadi kesehatan lingkungan bagaimana untuk menjaga dan untuk meningkatkan taraf hidup kesehatan anak-anak maupun masyarakat yang ada. Belum lagi kita bicara tentang sampah yang ada, sampah yang populasi air, populasi dengan kehidupan populasi masyarakat yang padat. Ya, oke. Next slide. Oke. Boleh selanjutnya juga. Nah, ini Nation Nutrition Program often suffer from poor enforcement mechanism. Marketing regulation-nya bagaimana ya untuk sampai ke masyarakat di wilayah pedalaman, perifer yang mereka sulit untuk mendapatkan makanan nutrisi yang penting untuk tubuh. Keadaannya tidak hanya stunting yang ada di masyarakat. Jadi anak-anak itu sebenarnya bukan permasalahan kesehatannya hanya stunting saja, tapi yang dimaksud dengan poor nutrisi pada anak itu adalah dalam dunia medis itu ada yang disebut dengan kwashiorkor, ada yang disebut dengan marasmus. Marasmus itu biasanya tubuhnya kecil, kurus, tapi perutnya besar, buncit, ya kan? Tapi bukan pada dewasa, ini pada anak-anak. Ya, kenapa? Nah, balik lagi, kekurangan gizi nutrisi penting pada anak itu bermacam-macam. Jadi tadi kalau misalnya pada awal pemaparan saya mengatakan bahwa stunting itu adalah permasalahan yang memang sangat besar, tapi kita belah lagi sub dari kekurangan gizi itu, dia masih ada 5 permasalahan gizi pada anak-anak. Dan juga dapatnya dari mana kekurangan gizi pada anak tadi? Berawal dari permasalahan ibu hamil yang mungkin adalah memiliki penyakit anemia defisiensi besi. Mungkin pernah mendengar kurang darah ya. Nah, itu yang biasanya kita sebut di bahasa medisnya adalah anemia pada ibu hamil. Anemia pada ibu hamil tadi mempengaruhi tumbuh kembang janin dan mempengaruhi tumbuh kembang anak. Salah satunya anak juga mengalami hal yang sama. Anak juga mengalami hal yang sama dengan kejadian saat ibu hamil. Jadi apa yang dialami oleh ibu hamil kayak KEK atau kekurangan gizi khusus pada ibu hamil menyebabkan tadi pertumbuhan dari masa otot anak, masa otot janin maupun perkembangan otak janin itu terganggu. Oke, kita lanjut. Social cultural barriers to nutrisi. Nah, ini juga yang menjadi permasalahan mungkin tidak hanya di Indonesia tapi juga di dunia. Traditional dietary ya, jadi diet yang tradisional ini yang cukup mengganggu. Mungkin ada yang sangat makan more sugar ya, banyak gulanya atau spicy banget, pedas banget dari makanan tersebut ya, atau salt ya. Jadi benar-benar kondisi yang makan berlebihan. Apa side effect-nya dari makanan dengan campuran bahan-bahan tadi yang berlebihan? Mungkin ada ada yang mengetahui kalau kebanyakan gula ini akan menyebabkan diabetik ya, penyakit gula. Atau kalau misalnya yang menyebabkan asin, ini apa penyebabnya. Nah, belum lagi beberapa wilayah, beberapa negara yang biasanya makanan protein itu hampir sama. Jadi bumbu spicy-nya, yang pedasnya itu seimbang dengan bahan yang akan dimasak. Ya, jadi dagingnya sekilo, bumbunya juga sekilo. Ya, kalau di Indonesia apa ya namanya, rendang biasanya nih. Nah itu kalau rendang dari wilayah Sumatera itu lumayan, dagingnya sekilo, bumbunya sekilo. Tanpa disadari terus meningkat setiap hari, dia nggak langsung menjadi penyakit. Tapi pada waktu 10 tahun kemudian yang dimakan tersebut itu yang akan menjadi permasalahan penyakit tadi. Tapi anehnya angka diabetik di Indonesia itu yang tertinggi sementara ini adalah di Kalimantan Barat. Ya, 2 tahun ini angka diabetiknya bukan di Padang, bukannya di Jawa yang terkenal dengan makanan manis, bukannya di daerah Jakarta, tapi di Kalimantan Barat karena informasi yang ada di Kalimantan Barat makanannya enak-enak. Dan semakin banyak wisata kulinernya. Oke. Baik. Selanjutnya ini hubungannya dengan kesehatan wanita, ibu hamil, pregnancy dan anak-anak. Ini sebenarnya apa sih? Nah, ini yang kita tadi PR bersama. Jadi tidak hanya permasalahan kepada para medis saja, tapi ini permasalahan global, permasalahan pemerintah, permasalahan yang sekarang diangkat oleh WHO. Karena anak-anak yang sehat itu merupakan ini masa depan negara. Jadi bagaimana tumbuh kembang anak-anak itu baik dan juga mempengaruhi pertumbuhan otak mereka. Berarti bisa berpikir dengan baik, bisa bekerja dengan baik dan juga bisa melakukan hal-hal terbaik untuk masa depan negara ini. Tuh. Beberapa negara yang sudah menetapkan aturan-aturan bahwa kesehatan gizi itu penting. Itu ada di Brazil, Peru, dan Vietnam. Mereka menekan angka stunting yang awalnya lumayan cukup tinggi, ya. Dari Brazil turun hingga 7%, Peru 12%, dan juga Vietnam itu turun sampai 18%. Ya, dan mungkin nanti akan disusul lagi oleh beberapa negara yang lain di Asia. Kita harapkan ada aturan-aturan bagaimana supaya kesehatan gizi ibu hamil dan anak ini akan lebih baik lagi dengan regulasi-regulasi rule yang lebih jelas lagi. Di Indonesia, sudah ada Permenkes, ya, aturan dari pemerintah juga kepada asuransi kesehatan yang memang menyampaikan bahwa ibu hamil, ibu menyusui maupun anak-anak itu ada aturan yang diberikan istilahnya mikronutrien atau obat khusus, ya, untuk mengejar ketinggalan untuk mengejar kesehatan dari tingkat gizinya. Itu sudah ada. Nah, itu yang tapi memang belum disosialisasikan secara menyeluruh, dan mungkin nanti akan kita harapkan ini akan terus aturan-aturan pemerintah ini maupun di WHO dan Asia di UNICEF akan lebih jelas lagi. Itu aja dari saya. Terima kasih kepada moderator. Thank you.
Thank you, Dr. Eka and Dr. Bufinder for the presentation. Maybe we can give applause to both of them. Okay, maybe I will give a short key takeaways from the presentation from Dr. Eka and Dr. Bufinder. And from these sessions, we've learned that nutrition is not merely a matter of health, it is a matter of law, equity, and justice. In Asia, continues to carry the world's largest burden of maternal undernutrition and child stunting, a challenge that reflects deep systematic inequality and weak policy enforcement. And Dr. Eka here emphasized that effective legal cooperation, both national and international, is essential to embed nutrition equity into global health frameworks. Strong laws can secure funding, ensure accountability, and protect nutrition as a human rights. And as for Dr. Bufinder, highlighted how artificial intelligence or AI and digital innovations are transforming healthcare, from diagnostic and telemedicines to personalized treatments and clinical trials. We've seen anti-aging research, once a futuristic dream, is now becoming a serious area of biomedical and public health focus. And now we open the floor for the next Q&A sessions for 20 minutes. Please remember to state your name and affiliations.
Saya juga nggak fasih berbahasa Inggris, Bu, jadi mohon izin pakai bahasa Indonesia. Tadi udah konsultasi, katanya nanti diterjemahkan, Pak, daripada maksudnya nggak tersampaikan, jadi lebih baik pakai bahasa Indonesia. Sebenarnya ini masih berhubungan dengan dua narasumber sebelumnya, tapi nggak apa-apa, ini biar ke Dr. Eka aja. Kita sekarang sudah punya undang-undang tidak pidana kekerasan seksual, kalau nggak salah nomor 22 tahun, ya pokoknya gitulah. Di undang-undang tidak pidana kekerasan seksual itu, perkawinan anak merupakan bagian dari tindak pidana kekerasan seksual. Nah, apa yang ingin saya sampaikan, saya ingin bertanya kepada para narasumber, mohon saran dan pendapatnya, karena mungkin kami di pemerintah daerah sangat membutuhkan saran dan masukan khususnya dari para narasumber yang hari ini kesemuanya akademisi. Bagaimana saran para narasumber terkait penerapan Undang-Undang Tindak Pidana Kekerasan Seksual pada masyarakat adat. Ini menjadi tantangan tersendiri karena masyarakat adat ini juga punya pedoman tersendiri. Kalau kita di umur 19 tahun baru boleh dikawinkan, tapi di masyarakat adat tidak seperti itu. Di beberapa masyarakat adat malahan sah-sah saja kalau melaksanakan perkawinan di bawah umur 19 tahun. Ini kita sangat mengharapkan saran ya, karena ini menjadi tantangan tersendiri dalam implementasi Undang-Undang Tindak Pidana Kekerasan Seksual. Kan nggak lucu nanti ada tokoh adat yang dipidana. Kita terus sosialisasi sejak undang-undang ditetapkan, tapi ternyata ini bukan hanya sekedar permasalahan sosialisasi, tapi juga benturannya terhadap adat yang sudah dijalankan dalam waktu yang cukup lama. Mengapa? Karena perkawinan anak ini berhubungan erat dengan stunting. Baru-baru ini Dinas Kesehatan Provinsi Kalimantan Barat menggelar pertemuan mengevaluasi salah satu faktor yang dominan menyebabkan meningkatnya angka kematian ibu dan angka kematian anak. Itu salah satu faktornya adalah pendarahan. Jadi narasumbernya saya tanya, dokter ini kalau pendarahan penyebab utamanya apa? Salah satunya itu adalah belum siapnya organ reproduksi dari si ibu. Idealnya umur berapa dokter? Idealnya. Seharusnya idealnya umur 21 tahun Pak. Bayangkan, umur 21 tahun itu dianggap ideal, namun kenyataannya ibu-ibu muda di umur 21 tahun itu cukup banyak yang mengalami pendarahan yang akibatnya meningkatnya angka kematian ibu dan angka kematian anak. Nah ini menjadi atensi khusus bagi kita dan mungkin kepada adik-adik yang khususnya calon ibu. Iya kan? Kita kan harus mempersiapkan calon ibu, calon ayah ya kan? Karena kami semua yang sudah lebih dulu akan meninggal dunia dan akan digantikan oleh generasi muda. Dan ini akan berhubungan sama dengan masa depan bangsa Indonesia tercinta. Jadi sekali lagi kami mohon saran dari para narasumber terkait implementasi Undang-Undang TPKS pada masyarakat adat. Karena ini akan sangat berhubungan dengan pencegahan stunting. Jadi ini mungkin bisa secara khusus di Kalimantan Barat atau mungkin juga secara umum di Indonesia. Terima kasih. Saya Abu Samah dari Dinas Pemberdayaan Perempuan dan Perlindungan Anak.
Thank you for the question. Maybe before we give the speakers to answer the question, maybe I will translate it so another speaker can answer the question too. So the question is, Indonesia has enacted the Sexual Violence Crimes Law or Undang-Undang TPKS, and early marriage, specifically child marriage, is often framed as an act of sexual violence under certain interpretations of these protective laws, or at least a related serious crime. We know that state law, specifically the marriage law, sets a minimum age for marriage, currently 19 years old, for both genders. And however, child marriage remains a persistent issue in many customary law communities where traditional norms or social pressure may permit or even encourage it. The question is, to the distinguished speakers, given the theme of legal pluralism in Borderlands, we seek the advice of what is the most appropriate and effective enforcement strategy against the crime of sexual violence as related to the child marriage within customary communities without completely disregarding the customary authority and social culture. This issue demands special attention because the lack of physical and mental readiness of the child for pregnancy often leads to severe public health consequences, particularly contributing in stunting in the subsequent generation. Thank you. Maybe we can give the opportunity to Dr. Eka first to answer the question.
Baik, terima kasih Bapak Abdul Salam. Izin bahasa Indonesia juga ini Pak jadinya jawabnya. Mungkin saya untuk aturan yang berlaku pada hukum adat mungkin mohon maaf ini bukan ranah saya juga belum terlalu paham, tapi mungkin saya akan menyampaikan sharing tentang usia aterem, usia matang untuk seseorang itu melakukan pernikahan atau hubungan seksual, pertama kali hubungan seksual. Nah, jadi usia anak itu menurut WHO itu adalah usia 0 kelahiran sampai 18 tahun. Nah, jadi setelah 18 tahun itu baru masuk tadi usia remaja akhir. Belum dewasa. Nah, jadi belum dewasa. Dewasa itu nanti setelah tadi benar Bapak sampaikan di usia 21-22 tahun. Nah, jadi jadi kita biasanya kalau dalam dunia medis itu kita mempelajari usia bayi, balita, anak, remaja awal, remaja akhir, nah baru masuk usia dewasa. Kapan bisa pernikahan itu? Hubungan seksualitas pertama kali dilakukan adalah saat usia dewasa. Karena secara anatomi berarti fungsi seksual baik itu pria dan wanita itu sudah matang, sudah aterem. Nah, salah satunya tadi memang kalau misalnya terjadi kehamilan dan lahiran itu menyebabkan stunting, salah satunya juga adalah yang meningkatkan angka kanker CA. Ya, CA rahim, CA leher rahim yang meningkat saat ini itu dikarenakan usia pernikahan, usia seksualitas pertama kali hubungan seksual itu dilakukan tadi pada usia anak akhir atau remaja awal. Mengingat sekarang itu sudah sangat kita lampu merah ya, bahwa usia seksual itu cukup bebas di kalangan remaja. Bahkan kita juga ada PR di HIV dan AIDS ini yang cukup tinggi, selalu meningkat. Nah itu tadi, karena usia, walaupun bukan usia pernikahan bahkan, jadi usia hubungan seksualitas itu di usia remaja itu hampir banyak dilakukan anak-anak yang memang belum matang secara anatominya. Nah ini yang menyebabkan tadi, kalau kita bicara masalah stunting, berarti itu masih jauh ya ke belakang, tapi yang paling cepat ini didapatkan tadi adalah kanker leher rahim dan rahim. Nah itu yang kita takutkan. Nah ini kita berharap ada aturan-aturan jelas nih gitu kan, kolaborasi antara pemerintah, hukum, undang-undang pernikahan dan juga hukum adat, mungkin seperti itu ya. Nah yang menjadi pengalaman saya saat berkunjung ke wilayah perifer Kalimantan, biasanya anak-anak mereka itu sekolahnya jauh, berkilo-kilometer dari tempat tinggal. Nah jadi untuk pergi sekolah aja itu sudah butuh perjuangan. Pada akhirnya orang tuanya sudah menyampaikan, ngapain susah-susah sekolah, kawin aja gitu kan. Nah ini yang biasanya jadi nggak sampai tuh di usia level yang masih harusnya junior school ini di SMP, SMA itu ya udahlah. Karena tadi pengaruh dari budaya dan pengaruh dari orang tua yang menyampaikan ngapain sih sekolah jauh lagi berapa kilo, balik nanti nyampe ke rumah malam, belum hujan, belum apa, lumpur, segala macam, infrastruktur kita juga yang kurang baik. Nah ini yang menyebabkan masyarakat di wilayah perifer itu biasanya udahlah nikah aja. Pernah kami mengalami di rumah sakit Untan itu usia 19 tahun itu sudah memiliki anak ketiga. Dan itu sudah terjadi ruptur uteri, ruptur itu kayak pecah gitu loh, di dalam rahimnya itu udah banyak gores-goresan, jadi menyebabkan pendarahan yang sangat berat. Karena tadi usia muda, ya 19 tahun, anak sudah 3, ya jadi yang belum matang secara seksual, belum matang secara rahimnya, tapi sudah dipaksakan tadi. Begitu hamil anak ketiga, terjadilah, dan ini melahirkannya 1, 2, 3 di bidan, di daerah. Dibawa ke rumah sakit Untan, dibawa ke dokter objin kandungan, itu sudah 50% darahnya sudah habis gitu. Nah itu yang sulit diselamatkan tadi. Nah, ya mereka nggak tahu, dari segi keilmuannya pun udah nggak tahu tadi ya, keluarga juga nggak ngerti, ditambah lagi bidan yang saya nggak tahu apakah memang benar-benar bidan. Saya kalau bidan yang memang legal sih mungkin tahu ini angka yang ini nilai yang baik bisa untuk mengalami kelahiran secara normal. Nah takutnya ini bukan bidan secara profesi, mungkin apa ya istilahnya kayak dukun kampung gitu loh, yang membantu persalinannya tadi, ditekan-tekan aja akhirnya ruptur, koyak di dinding rahimnya. Ini yang menyebabkan pendarahan, bayinya belum keluar, angka kematian ibu dan balita juga ada, padahal kita berusaha angka kematian ibu dan balita itu adalah 0. 1 aja kejadian itu berarti sudah angkanya sudah menjadi evaluasi di dinas kesehatan, seperti itu. Mungkin sedikit menjawab untuk bagian medisnya ya Bapak ya, mungkin di bagian hukumnya loh nanti saya kembalikan ini ke teman-teman speaker yang lain. Terima kasih.
Maybe because due to the time constraint, for the question, maybe the speakers can answer outside the forum. Yeah, maybe another speakers can write the answers or maybe the recommendations for the questions in the chat room in the Zoom before the Zoom is ended, because our time is limited and we must now conclude the Q&A sessions. Yeah, so and my sincere thank you for our distinguished speakers. Your contributions have significantly enriched the conference, and please join me in giving a final resounding round of applause to Professor Gary I. Lilienthal, PhD, Dr. P.J. Ismail bin P.J. Musa, Dr. Bhupinder Singh, and Dr. Eka Ardiani Putri Mars MH. This concludes our sessions. Thank you for your active participations. I now hand the floor back to the Master of Ceremony. Thank you.
Thank you, Ms. Anissa Azamifa, as a moderator. Ladies and gentlemen, we can call it a day for this conference, day 1, with agenda presentations from the speakers. The conference will continue at 12:50 p.m. at the Zoom meeting applications. And now our guests can have a meal at the registration table. We would like to invite you to attend the second day of conference, which is tomorrow. And on behalf of committee on duty, we would like to take our leave. We apologize if there's any mistakes. Thank you. Assalamualaikum warahmatullahi wabarakatuh.
Hadirin yang berbahagia, kita memasuki waktu istirahat untuk makan siang dan ibadah. Acara akan dilanjutkan kembali pada pukul 12.50 dengan sesi panel paralel secara online. Silakan menikmati waktu istirahat Anda. Terima kasih.